Good morning, everybody. Thank you for coming out on a rainy Saturday morning. My name is Charles Irvin. I have here Dan Charest and Larry Dunbar. These are two of my co-counsel in this case. And what we're going to do today is first introduce ourselves, tell you a little about who we are and how we came into this litigation. Then we're going to sort of talk about the lawsuit, what it means, what the legal theories are, how we got into this situation where everybody's homes around here are flooded. And then we're just going to open the floor and answer all of your questions. And we've done many of these public meetings, and you know, it's clear a lot of people have questions. So we're also here to primarily answer all your questions to the best of our ability. So kicking that off, my name is Charles Irvin again. I'm a partner at the law firm of Irvin and Connor up there at the top. My law partner, Mary Connor, is also here in the back. I am an environmental lawyer here in Houston. I have a small law firm that just does environmental law, and part of environmental law is flooding cases. So we do drainage cases, we do flooding cases, and that's kind of our background and experience. Also over here in the corner, I have Larry Dunbar. Larry Dunbar is a licensed professional engineer and hydrologist. He specializes in drainage issues. He started out, well, I guess not started out, but one of his former jobs was working for the Corps of Engineers in another state, running their dam safety and reservoir operations up in Chicago. The Chicago office, Larry? Yeah, so in Minnesota and Chicago and Illinois. So he has a lot of background in, you know, Corps of Engineers operations and how they operate their dams. Also, Larry is a lawyer. So he's that dangerous combination of engineer and lawyer. And that makes him very useful. So I sometimes co-counsel with Larry as a lawyer, and sometimes I hire him as an expert to testify in our cases. So that's what Larry is very useful for, and he knows how to dig into technical documents. He knows probably as much about the Addicks and Barker reservoirs as the Corps of Engineers knows. One of our former capers together was suing the Corps of Engineers when they authorized the construction of the Grand Parkway. So that section of Grand Parkway from I-10 north to 290, and when that went in a couple of years ago, well, we sued the Corps of Engineers because they didn't adequately analyze the impact of all the increased development because the Grand Parkway went in, and the impact of that runoff on Addicks Reservoir. When we did that litigation in 2011, we also had access through that litigation to an enormous library of Corps of Engineers documents. That's how we got to have a very good understanding of how these reservoirs are constructed, how they operate, how they were always intended to operate, and that's kind of one of the reasons why we think we can really drive this litigation forward very fast. I'll let Dan introduce himself because he's standing up here waiting for the microphone.
So I'm Daniel Charest. I live in Dallas. I've got my own law firm there. I worked I've been a partner at a prior law firm, and throughout my career as a lawyer, I've worked on what I would classify as complex commercial cases involving classes and mass torts and big sort of gnarly cases like this one. And the way I got introduced into this whole group is actually through Mary Connor as well. Mary and I worked together for the same judge when we finished law school. And when Mary and Charles had these cases come up, she thought she would reach out to me and bring in our experience on how to deal with the MDL and MDL meaning multi-district litigation type issues that are going on in the case. And talking about leadership structures and how to deal with hundreds and hundreds and hundreds of clients, thousands of clients, and also how to deal with the class issues and how to get a class certified and adjudicated to get relief for everybody that flooded. So that's kind of my angle. Or in my view, I see Charles brings the substantive expertise on flooding, and we bring procedural expertise in the way to handle these cases in the court on a mass basis. And so together, I think we have put together a really nice panel of lawyers. We also have in addition to just us. It's not just us. We have Larry Vincent, who works with me in my shop. He's a former Supreme Court clerk, not justice, clerk. That would be interesting. And he's spent the past 30 years of his career working on takings cases. And so he has very strong takings expertise. And then, of course, Larry Dunbar with the hydrology. Together, the group here, I think I'm very proud of the panel we put together.
All right, so I thought I'd start off, before we get into the technical stuff of how these reservoirs work, I'll tell you a little bit of story about how we came to be involved in this litigation. Just very briefly, Harvey came along over that weekend, that very, very long weekend that never ended. The rain came and it poured. A couple of days while the reservoir pools were still flooding your homes, a couple of days into, Harvey, I think it was like maybe the Thursday, we got a call from somebody up in one of the subdivisions behind Barker Reservoir. It's actually in Canyon Gate, a woman called Christina. And she said, I hear you guys do flooding cases. Can I come in and see you? And so we met with her and 3 other ladies, and they said, we hear there's been some lawsuits filed because of the flooding in Harvey. And when we read about them, they were all lawsuits about the wealthy people downstream along Buffalo Bayou that flooded. Why isn't anyone signing up people in the upstream side? We flooded as well. My subdivision has 790 homes, and every single home in that subdivision flooded. And so Larry and I listened to their talk, their story, and a few days afterwards we got together and we said, it's the upstream cases that are the simpler cases. Downstream, you had all sorts of difficult hydrological issues. There's all sorts of legal issues about, opening the gates and, why they made a decision to open the gates. But the upstream case, we felt, was much simpler, right? The upstream case is simply that the federal government built a reservoir. They designed it to hold a certain amount of water, but they didn't buy enough land to hold all that water on. And so private developers came in, built subdivisions, Twin Lakes, Lakes on Eldridge, Cinco Ranch, all those subdivisions, Kellywood, on land that is inside a federal flood reservoir. And we felt that that was a very simple case. I mean, what's the federal government going to do? Deny that that's their water? No, it's their water. It was impounded behind those dams. So we got together, and in 24 hours we put together a lawsuit. We styled it as a class action because at the time we only had one client. But we all knew that everybody behind those 2 reservoirs, what we call the upstream cases, flooded for the same reason, because the federal government decided to impound water on your private property without your permission and without compensating you for it. And so that's the sort of how we came to file this lawsuit. Ours was the first lawsuit that was filed for exclusively upstream clients. At the time, all the other lawsuits were downstream, or might have been sort of confused where they think that the upstream flooded from the releases going around the back end of the dam. So we basically filed this lawsuit. The Court of Federal Claims is where we filed it. That's the only place where you can file a lawsuit claiming money damages against the United States of America. And we didn't sue the Corps of Engineers. You can't sue an executive agency under this theory. You sue the United States. So the case is styled Christina Miku versus U.S. What happened next was the chief judge of the Court of Federal Claims saw all these lawsuits, these Hurricane Harvey related lawsuits being filed. Each day, more and more lawsuits were being filed. Some other lawyers saw our lawsuit on the upstream side and copied it and put their own names at the bottom and refiled it and things like that. That's the kind of thing that goes on sometimes. But eventually, after a few weeks of this, the chief judge of the Court of Claims announced that she was going to come to Houston and was going to have a status conference here in Houston. That's one of the nice things about the Court of Federal Claims is they come to you.
On a case like this.
On a big case like this. So she came down here and she asked for sort of position statements from various lawyers about how they viewed their cases. And so we put in a position statement that essentially said there are 2 different cases here. These are not all Hurricane Harvey and Barker cases. There are upstream cases and there are downstream cases. They're two very different things. The upstream case is simply, did the pool impounded by the Corps of Engineers rise onto your property? The downstream cases are, why did they open the gates? Was there other reasons why you flooded? And much more complicated. So we were successful in persuading the judge that these two cases need to be treated separately rather than all together. It also took away one of the government's arguments that, you know, oh, we were stuck in between the upstream and the downstream, it was an impossible situation, you know, we had to flood both of them a little. That was one of their arguments they were going to make. So we took that argument off the table by keeping the cases separate. So now there are two entirely separate cases, upstream cases, downstream cases. One of the things that the judge also did was treated this case as what's called complex litigation. In other words, there are lots of individuals who are suing for similar reasons. There are lawsuits that are class action lawsuits like ours. There are lawsuits that are just one plaintiff, one homeowner. There are lawsuits that are 300 homeowners, all suing with different law firms involved. Now that kind of gets chaotic, and Dan can speak to that, how judges, you know, basically manage the case when they have a lot of different cases like that.
Sure.
The way we call it MDL work, so multi-district litigation. And you all seen advertisements on TV for, you know, this drug or that drug, or when you have an injury that is spread across a lot of different areas, and you have what happens is people sue in their local courts all across the country, and then there's a process in the federal government and the federal courts where they bring all the claims together in one location. They appoint a chief judge for that location, and the chief judge then turns around and says, all right, well, I need to get a leadership structure in place so I don't have to deal with, you know, 1,000 different plaintiffs' lawyers. I just want to deal with this handful here, this handful here. The chief judge of the Court of Federal Claims, even though it's just one court, so you don't have the multi-district, literally, she applied those principles to these cases and had everyone submit their leadership suggestions on how they, you know, basically it's like a job application. You tell the judge, well, we want to be in charge because we think we can, you know, achieve these different things and these different things. And we made an application, my firm, with Charles's firm, and we listed Mr. Dunbar as someone that's on our team, and also Larry Vincent. And of all the lawyers that were out there vying for some sort of leadership position, the judge ultimately selected 12, 6 for upstream and 6 for downstream. And of the 6 for the upstream lawyers, she selected 3 people from our group. So it's myself, Charles, and Larry Vincent, who couldn't be here today, are 3 out of 6 of the co-lead counsel for the upstream cases. And those are the group. That's the group that you're talking to here. That we are all working together collectively. Well, first off, all 6 of us are working together for the benefit of everybody. But we, the group I just said, are signing clients as individual clients through our sort of collaboration. If that makes sense. So the judge appointed us as leadership, and what that means is we have a responsibility now, not only to our clients that we sign up, but also to everyone that is in the upstream area. And that's why we've decided our plan is to bring a class in order to get relief for the entire group. And I can talk about class now, or do you want to talk about it after?
We'll get onto that later.
We'll get onto it afterwards. But that's the leadership structure. There was a leadership, basically the job application, and the judge picked the 6 lawyers that she picked, and 3 of them are here.
All right, thanks, Dan. So let me get to what you're probably really wanting to know about. How did we get here? How did we get to a point where essentially over 10,000 private homes and businesses ended up being built inside a federal flood storage reservoir, right? I'll show you a little thing. So normally when the federal government builds a reservoir, they're looking at 2 things. They are looking at what is the purpose, and for Addicks and Barker, the purpose is storage of floodwaters, right? In 1920-something and 1935, there were heavy rains in the Addicks and Barker watershed, which at the time all flowed down into Buffalo Bayou, And those rains at, I can't remember what they were like, was it 30 inches or so? 16 inches, right? 16 inches, that's not very much. Flowed down Buffalo Bayou and caused catastrophic flooding in downtown Houston. So about 10 years later, in 1944, Congress appropriated $4 million, not a lot of money, but a lot of money back then, and instructed the Corps of Engineers to build something called the Buffalo Bayou Tributaries Project. That project, as it initially was designed, was, well, first of all, it was one big reservoir, but they couldn't build one big reservoir because you've got I-10 going between the two. So they ended up 2 reservoirs, Addicks and Barker. The project also at the time conceived of other components, which even back in the 1940s they understood were important. So there was going to be a levee constructed along Cypress Creek to stop what's called the Cypress Creek overflow, where when Cypress Creek gets up, it jumps its bank and it jumps across the watershed divide, it flows through Bridgelands, and it comes down into the Addicks Reservoir. So about 30% of the water that ends up in Addicks actually comes from Cypress Creek. So there was going to be a levee to cut that off. There was going to be a 3rd reservoir on White Oak Bayou. And then finally, coming out of the 2 reservoirs, coming out of the 2 big reservoirs, there were going to be 2 huge canal systems, one going out of Addicks, curving around north of downtown Houston and dumping into the San Jacinto River, and another going south of downtown Houston and going into Galveston Bay. And that's how they were going to empty the reservoirs. As you know, those other components outside of the 2 big reservoirs were never built. They were never built. And some of the things that we're talking about now about solutions to Addicks and Barker involve some of those similar kind of components, but they weren't built. There was another somewhat crazy plan to drain Addicks and Barker underneath I-10 in huge sewers that flow underneath I-10 all the way down to past downtown. Anyway, so we got these 2 big flood storage reservoirs that were built. How do they work? They basically rely on an earthen levee on 2 or 3 sides, and then that earthen levee contains water behind it, and at the backside you've just got the natural elevation of the ground forming the other side to keep the water in. So water flows downhill, collects in pounds behind the dam, and then fills up. Now when you design a reservoir, there's 2 important things you think about. One is, how much water do you want to store in that reservoir? And so when the Corps of Engineers built this, they designed it to store a certain amount of water. And the way they talk about it is, what is the elevation of the pool surface, above sea level? And the second thing that you think about with a reservoir is, once I have this elevation of water, how much area of land will it cover? Okay? So you've got a pool, it covers an area of land and it has an elevation. Here we have a couple of cross sections of Addicks and Barker. How many people are from Addicks? And the rest from Barker? So about half and half. So I'll talk about both. But essentially what you've got is they design a reservoir that can hold, for example, with Addicks, the maximum design pool is 115 feet. 115 feet elevation. The land, when they bought the reservoir, when they purchased land to hold that much water, they only bought enough land to hold 103 feet elevation of water. So they purchased about a little over 12,000 acres of land. In Addicks, 12,000 acres of land stores less than 60% of the design capacity. So there is a bunch of land that is not owned by the federal government, that is outside the limit of that nice green park, that's all the federal land, that remained private. And back in the 1940s and 50s, it was ranch land, it was rice fields, it was pasture. People probably didn't care if they flooded occasionally. But over the decades, development started, subdivisions went in, and we got to where we are today. Similar with Barker, same thing. They have a design pool of 108, maximum design pool. The federal land pool is about 95-foot elevation, and what we had in Harvey was 101.5. So Harvey filled up the federal government land, and the figures for the area of land owned by the federal government in Barker are almost identical, except that Barker only has enough federal land to store 40% of the water. So 60% of that capacity is being stored on private property. So, you'd think that would freak the Corps of Engineers out. You'd think they say, oh my God, people are building homes in our reservoir, what should we do about it? Well, it kind of did. And we have documents going back to the 1960s, 1970s, 1980s, where they look at the problem and they write it down in black and white. And they say, problem, particular problem, flooding of non-federal land by the reservoir. We see lots of subdivisions going in. These are being built in a reservoir. One day these will flood. This will result in litigation. What should we do? We could work with the local government and restrict development. We could go in there and buy flowage easements to prevent development. Or we could do nothing. Or we could do nothing and accept the risk. And so decade after decade, the Corps of Engineers sat back and watched subdivision after subdivision after subdivision being built in their own reservoirs. They have known this is a problem. They've known this day would come. They knew this litigation would come. So don't feel bad about, kind of joining a lawsuit against the United States of America, because they knew this problem was going to happen. They've always intended your land to flood. And the worst thing is that the design of the reservoirs is not even the design, the capacity they're intended to hold. Each of those in Addicks and Barker, they're designed to hold about another 5.5 to 6 feet of water over what we had during Harvey. Right, so they said, what is the biggest possible storm we could have in the Houston area? How much water will that result in? If we store it in Addicks and Barker Reservoir, what's going to be the elevation? And it's 5.5 to 6 feet more than what any of you had in your homes during Harvey.
I want to just add on the whole notion of, the righteousness or not of joining to the lawsuit. One of the aspects of the type of case that we're talking about here is, the core aspect, it is a takings case. And the concept behind takings is that the government is not allowed to take your property without compensation to you. Now, it reaches back all the way back to it's in the Constitution for a reason. Before one of the main complaints that the colonies had against King George was that the armies would come through, people would come through, just take something from their home. Okay, they would just knock on your door and say, I need a goat, a cow, 3 loaves of bread, and thank you very much, and it would just leave. Or we're sleeping in your house tonight, and you can't do anything about it. They would just take over, and back then, the rules where the law is, and sort of a fundamental principle of law, is that you cannot sue the sovereign. You couldn't sue the government to do anything about it. They would just take and not offer you compensation back. Now, the trade-off there is the concept behind a takings case is society needs sometimes for the government to take something from a certain set of individuals in order for the greater good. When we talk about the flood pool, the benefit to society writ large is that the entire city of Houston didn't get wiped away, and billions and billions and billions of damage dollars and injury downtown, and probably hundreds or even thousands of people die. Now, that is a good thing that didn't happen. To get that to happen, though, to get that benefit for society, they put water on your property. They flooded your homes. All right, and so the concept is, well, society benefited, right, from saving the city of Houston at your expense, but you shouldn't have to bear that expense yourself. So now you go to the government and say, we would like to get reimbursed for what you took from us. And it's simple as that. It's not like, I've heard people say, well, why should we sue? We knew we lived there. It doesn't matter about what you knew or what you didn't know. It doesn't matter whether, it doesn't matter anything other than the fact that the government came and took property from you. All right, and that's the core principle. There are other details to it, but that's the core principle behind the takings case.
And so yeah, should we take some questions?
Sure.
Or, yeah, let's take a question or two.
My question is, so when we receive compensation, it's like, it's gonna be individually, right? Like it will depend on the loss.
Yeah, yes, so, the question was, if we receive compensation, it will be based individually on your individual damages. The answer is yes. So, we filed a class action. There are other lawsuits that are individual actions, but our objective, and we think the court will go with this, is to try and get a single determination of liability for everybody. Everybody, because you all flooded for the same reason. Once we get, and to do that, we have to use a mechanism called the class action in order to get the liability determination for class representatives for test properties applied to all the other properties, because this court does not want to have, 8,000 individual trials in front of, a bunch of different judges, resulting in all sorts of inconsistent rulings. So I think a lot of people think that the liability phase will be determined as a class so that everybody benefits from the liability finding. Once you have a finding of liability against the federal government, the only question that remains is how much money you're entitled to. And unlike class actions against companies like Apple Computer or something like that, this is a class action against the federal government. This is being paid for out of taxpayer dollars. And so the federal government is going to require that that money only goes to people that genuinely deserve it. There's not going to be some universal global settlement where everybody gets $50,000. We don't think that's a remote possibility because the federal government just won't agree to that kind of thing. They're going to say, you, ma'am, how much property damage did you suffer? How much did it cost you to get back in your home? How much did you lose in contents? What is the diminution in your property value?
Is it gonna include the new value of the homes, like the amount we lost because of the
So the question there was really goes to how to measure damages, and let me defer that because we'll talk about that later on in the presentation. I'm sorry, but I wanted to take up one point that Charles said there. The way the structure that the court has in place now is focusing on liability only. When you look at a case from a plaintiff's perspective, you think of two core principles. One is there liability, and if so, what are the damages? All right, that's do they owe me money? If so, how much? Okay. The thing that we're looking at now, that we're working on now with the court, is to establish liability, but liability only. And the idea, the current schedule we have is to come to some sort of decision on that in the fourth quarter, end of third quarter, fourth quarter of 18, and on the summary judgment on briefs. And if that doesn't work, to try and have a trial, as I understand it, in the first quarter of 19, which, when your house is flooded, that doesn't sound very quick, but I can tell you from a lawyer's perspective, that is very fast. And that leaves a note on that. The judge has made it very clear that the chief judge has been very clear that she wants this case handled expediently, and she really has taken it on herself, I think, in remarkable fashion to try and show the flood victims, y'all, that courts can serve justice quickly and can bring relief to the people, and I think it's. We welcome that, of course, as the people representing y'all, but that's the schedule. So hopefully we'll get to liability determination by the end of 18 here. Now, on the question of damages, that work going into the trial will not really focus on what I would call the quantum of damages, how much the particular plaintiffs that are representative cases, how much they actually are owed. They'll have to show the existence of damages as an element, but not the amount, really, is my understanding. that said, our plan for our clients, because, and this dovetails into just this sort of individual versus class thing. When the class runs its whole course, if we do get to the end of this year and get a class determination that yes, on behalf of the entire class, the government, owes you money, they are liable to the entire class, you're still gonna have to answer the second question. Well, what are my damages? There is a chance that we can get that done on a class basis. It'll still have some individual aspects to it. There's a chance that we can do it on a class basis. We haven't really pushed that now, and I don't think we will push that now. My ambition for the clients that we sign individually is to work up your damages over the course of this next year, so that when we do get to the end, when we get to a liability determination, the clients that we have will be ready with their damage packet in hand, and they'll say, here we are, oh, that's what our damages are. We don't have to restart at the end of 18, just try and find out what are your damages. And that's good for a couple different reasons. Number one, just for timeliness in the recovery phase, so you're ready if we get to the win, that you have the damage packet ready. But number two, you as individuals, you have receipt. You probably have a shoebox full of receipts. You've got file folders and stacks. I have to make it personal. I was in New Orleans for Katrina, so I know exactly what I had a stack of stuff outside my house and the tape on the refrigerator. I know exactly what you're dealing with. And then you have this box full of stuff. So the point is to let you give us your box full of stuff. Let us work with you to get the damages ready, so that when we get to the end of the line here on liability, we have a cadre of people that are ready to go forward and ready to say, all right, now we're ready for the next step and get it done here. And so that's to the damages question.